Hearing in the Mitsui Co Ltd and other shipping appeal.
Mr. Kelly.
My Lords, may it please you. My Lords, I appear in this matter on behalf of the appellants, together with my learned junior, Mr. Richard Saul. And the respondents are, as you know, represented by Mr. Simon Crowell, QC, and his junior, Mr. Paul Toms. Now, your Lordships know what this case is about. It is about whether shipowners' costs incurred in negotiating a reduction in ransom demanded by pirates to the benefit of all of those involved in the maritime adventure should be borne by those who stand to benefit and do benefit, or whether they should be borne by the shipowner alone. The Court of Appeal says they must be borne by the shipowner alone. My Lords, we say that is wrong and has unfortunate consequences. In decoupling the costs from the benefits, the decision of the Court of Appeal has undermined important incentives in the law of general average, which as a body of law has as one of its primary objectives to ensure that in times of peril to the maritime adventure, the shipowner will act for the common benefit, without regard to the interests of individual parties, on the understanding that each individual's costs of so acting and any losses attendant on so acting will be made good in proportion to the parties' interests in the adventure. The aim is to ensure that the owner can disregard the individual interests and act in the common interest. In the case of a pirate ransom, we say that that objective is best served and encouraged by allowing an owner to negotiate where the costs and risks of negotiating it make it safe to do so and are likely to be outweighed by the saving in ransom, and also to continue to negotiate further for as long as the marginal costs of continuing are likely to be outweighed by a marginal further reduction in ransom. And we say that is the economically efficient result. But if a shipowner bears the whole costs of negotiating, perhaps over many months, the incentive on him will be limited to the reduction in his share of the ransom, which may be small, sometimes is very small, fraction of the ransom at the end of the day. He will not be incentivized to negotiate for the common benefit, but only for his individual benefit, and that may place his interest in conflict with the common interest, which may gain from further negotiation, but only at disproportionate cost to the shipowner. Now, my Lords, these points are made in our case at paragraphs 38 to 40. I don't ask your Lordships to look at that now, but for your reference, that's where we make them, where we also describe the Court of Appeal's decision as fraught with undesirable consequences. My Lords, the Court of Appeal's decision also frustrates the principal purpose of Rule F, which I know your Lordships will have seen. Your Lordships need to find it. It is in the core bundle at it's tab 8.8. And the rule itself is at the electronic reference number 442.
Thank you.
Any extra expense incurred in place of another expense which would have been allowable as general average shall be deemed to be general average and so allowed without regard to the saving, if any, to other interests, but only up to the amount of the general average expense avoided. Now, we say the principal purpose of Rule F is to ensure that if one party to the adventure has incurred expenditure in the course of reducing the general average contributions of all, that expenditure should be shared ratably by all. We say that is fairness. It's a rule that also encourages efficient substitution of one expense for what will be a greater shared expense, but only on the understanding that the substituted expense will also be shared. If Rule F is unnecessarily restricted in its application, efficient substitution is correspondingly prevented or restricted. And so we say the result achieved by the Court of Appeal is both unfair and inefficient.
You're concentrating at the moment on issue 1.
I am, my lords, I'm...
It had occurred to, I mean, quite rightly,
Yes.
it had occurred to us that there might be something to be said for you dealing with issue 1 and then the respondents replying on issue 1 and then turning to issue 2. I don't know whether you have a view on that.
My lord, we have not discussed it. I have not got an immediate view, but I can see some merit in that. Yes.
Mr. Pearl?
I'm content with that, my lord, as
Okay.
of course.
That's how we'll proceed. Thank you. Sorry to interrupt. Thank you.
No, my lord. I'm very happy to be guided in whatever way.
No, that's very accommodating of you both.
Yeah.
Thank you.
My lords, the respondents in their case say that the restrictions that prevent the allowance of my client's negotiating period expenses in this case are inherent in the operation of Rule F. But I must at this stage notice a contradiction in the respondent's position, which again for your note, my lords, we have dealt with in our case at paragraphs 34 to 35. That's page numbers 80 to 81.
Yep.
The respondents have never objected to sharing the direct costs of actually negotiating the ransom. That is to say, the time costs of Captain Gans, who was an employee of the vessel's managers and who was the actual interlocutor with the pirates, nor the costs of the ransom consultants, NYA, who advised him, very largely their costs of their time, but they do object to sharing the time costs of crew wages and bonuses necessarily incurred during the negotiating period. And we ask rhetorically, what is the difference? The difference, my learned friend says, is that the former expenses, that's to say Captain Gans and NYA, were intentionally incurred for the common safety, that is to say for the purpose of preserving the property at risk in the pirates' hands from peril. In effect, that the incurring of those expenses was a general average act, in the same way that the eventual payment of ransom to secure the release of the vessel was a general average act. And implicitly, he must also be saying that the incurring of crew wages and bonuses during that period was not a general average act. But, my lords, we doubt whether it can properly be said that the costs of actually negotiating the ransom were incurred for the common safety. My lords, it's clear that that involves a fairly precise intention. If I can just pick up how that was dealt with in the Court of Appeal. Again, I think I'd give your lordships references rather than ask your lordships to look at it now. It's on the electronic page number 220, paragraph 92 of the judgments. First of all, the judge is quoted as observing, so long as the act is done specifically for the purpose of preserving the property from peril, that purpose need not be the sole and exclusive purpose. And further in paragraph 93 on the same page, my Lord Justice Hamlin refers to the purpose being an effective cause of the incurring of the expenditure. So that is the territory, a specific purpose and an effective cause. But my lords, negotiation of ransom, to reduce it down, is about money, not safety. It involves refusing the pirates' demands and terms for the safe release of the vessel, holding out for a lower amount, while at the same time extending and continuing the peril to which the adventure is exposed while the vessel is in the pirates' hands. So it's not like paying a ransom. On the contrary, it involves not paying a ransom for as long as the risks and consequences of not paying can be borne. It's not done for the common safety. It is done at risk to the common safety. So, my lords, we say that the costs of actually negotiating the ransom, Captain Gans and NYA, cannot be justified as a general average act. They are properly admissible only under Rule F, as expenses incurred in place of paying a ransom, just as the costs in issue in this case are. There is no legally relevant distinction between the two sets of costs. Now, my lords, with those introductory observations, may I turn briefly to the principles of general average and the York-Antwerp rules. These days, they are effectively one and the same thing. The contractual incorporation of one version or other of the York-Antwerp rules into contracts of carriage by sea or for the hire of ships is so invariable as to be effectively universal. General average cases used to be part of the general diet of the commercial court in its early years. Indeed, your lordships, or some of your lordships probably know, that the commercial court owes its existence to general average. The mishandling of a general average case by Mr. Justice Lawrence in 1891 made the impetus for a specialist court irresistible. My lord, I'm referring to the case of Rosenbank of Australasia. There is an interesting article in the Law Quarterly Review for 1994 by Mr. Van Vechtenwede. But over the course of the 20th century, general average has fallen away. Indeed, it's almost vanished from commercial court practice, at least at the bar, and now it is a subject of such relative obscurity that even those who profess to practice in shipping law tend to shun and avoid it. My learned friends and I are some of the last survivors of the general average bar. Now, my lords, there are many reasons for that. One of them, I suggest, is the adoption of the York-Antwerp rules. Those rules were developed in the latter part of the 19th century, the early part of the 20th century, in the great effort to achieve international uniformity in the law of international trade and shipping. It's perhaps not entirely coincidental that the rules of 1924, that's to say the York-Antwerp rules of 1924, which set out for the first time a complete code for the recognition of losses and expenses in general average, should have been agreed in the same year as the Hague rules. As those rules have improved and refined, they have resolved many debates and difficulties, and they've operated smoothly over the last century and a half or more, certainly since the difficulties created by the misunderstanding of those rules in the Makis case was overcome. My lords, for your reference, paragraph 15 of our case, 72 to 73 of the bundle, tells you briefly about the Makis, but that was overcome in the 1950 version of the rules. One reason for the disappearance of dispute and litigation, as far as, certainly taken as far as courts and arbitration, is the role taken by average adjusters in the system. Now, average adjusters are highly professional men and women who have, more than anyone else, an intimate familiarity with the rules. And it's their task to calculate and assess the costs and losses consequent on a maritime accident and allocate them to one party or the other or to the general cost.
Some of us are honorary fellows of the Average Adjusters Association.
My lord,
Others of us aren't.
Whether that gives us a particular skill, I'm not sure.
my lord, I'm interested to hear that your lordship is so qualified, and I shall therefore shorten my more technical explanations to you.
I don't recall the discussion at any of their dinners covering the present subject.
I'm grateful.
And I haven't been to one for a long time.
My lord, average adjusters, although formally appointed by the shipowner as his agent to state the average, regard themselves traditionally as neutral arbiters between the various parties, allocating losses and expenses in good faith according to their best understanding of the applicable rules. There may, of course, be questions of fact and degree that arise in particular cases, but on the whole, those involved in maritime trade and their insurers have been content to accept the good faith assessments of the average adjusters, and direct challenges to general average adjustments are rare. But occasionally, some issue escapes from the happy consensus, and that almost invariably occurs where a real difference of professional opinion arises within the average adjusting community about the correct operation of the rules. And when that does happen in a small professionalized community, it is liable to generate strong opinions and much public ventilation of them. My lords, the last time that the operation of the York-Antwerp rules reached the appeal courts was in just such a case, the case of the Bigella, finally decided in the House of Lords in 1994. Your lordships will find it, but I don't ask you to look at it now. It's found in Appeal Volume 1.1 at tab 10. It may not be entirely coincidental that that case also concerned the allowance of substituted expenses, as this case does. We've set out a short and we hope uncontroversial account of substituted expenses and their introduction into the York-Antwerp rules, and such relevant authority as there is, at paragraphs 18 to 29 of our case, bundle reference 74 to 78, but that is really by way of background. The Bigella was concerned with a specific type of substituted expense, that is to say the expense of undertaking temporary repairs to allow a vessel to reach her cargo-carrying destination, and thereby avoiding various general average costs which would have been incurred if permanent repairs had been undertaken in the course of the voyage. The specific case of temporary repairs was governed by a particular numbered rule, Rule 14. We are, of course, concerned with the operation of the general rule, Rule F. But we say, it's necessary to do so, that the principle lying at the heart of both rules is precisely the same, namely, substitution of expense that otherwise would be shared in general average, with the effect of saving that allowable expense. And we'll have more to say about that case in connection with issue 2. What I wish to notice at this stage is that that case was another case where the average adjusters could not agree, as is clear from the report at first instance, which is at Authorities Volume 1, tab 8. Again, I don't ask your lordships to look at it now, but I can tell you this: the first firm of adjusters appointed, William Emsley and Sons, would not allow the costs of the temporary repairs. And the ship owners, being dissatisfied, appointed another firm to restate the adjustment, as they were fully entitled to do. That firm was Richards Hogg, now Richards Hogg Lindley, and they did allow the costs of the temporary repairs, and in those circumstances the matter proceeded to litigation, the trial judge and the Court of Appeal by a majority siding with William Emsley and Sons, and the House of Lords agreeing ultimately with Richards Hogg. Now, my lords, in this case, you have seen extensive reference in my learned friend's case to the views of Mr. Richard Corner, the current chairman of Richards Hogg Lindley. Mr. Corner also has the distinction of being one of the current editors of Lowndes and Rudolph on General Average and the York-Antwerp Rules, the leading text on the subject, now in its 14th edition, Authorities Volume 1-2, tab 22. But my lords, importantly, he was also the lead author of the advisory opinion of the Association of Average Adjusters on this very case, about which you will have read, I know, in the Statement of Facts, and without which I suggest this litigation would not have occurred. And he's also now the author of an article in last year's Journal of International Maritime Law, which your lordships have at Authorities Volume 1-2, tab 23, commenting on the decision in this case in the Court of Appeal. And my lords, extensive reference is made in my learned friend's case at paragraphs 12, 15, 21.1 and 56 to the views of Mr. Corner. For a variety of reasons, differently expressed at different times, he has been of the view that the negotiating periods in this case should not be allowed. You're also pressed, my lords, in my learned friend's case at paragraphs 21.3 and 151.3 with the views of Mr. Robert Miles Tomlinson, a more junior employee of Richards Hogg Lindley. and those views were expressed at a market seminar earlier this year, originally entitled Substituted Expenses, What the Rule F is Going On, and summarised now in a publication called Marine Risk International. I ought to tell your lordships, as I'm sure some of you will have detected, that Mr. Robert Miles Tomlinson is the son of Sir Stephen Miles Tomlinson, recently of the Royal Courts of Justice and now once again an arbitrating member of my chambers. Of course, his views are neither better nor worse for that. I dare say it is unusual for your lordships to be referred in the authorities' bundles to reports of market seminars, and much might be said of the opinions expressed by Mr. Tomlinson. In particular, he appears to have overlooked or ignored the problems presented by the Hudson conundrum. But what my lords do take issue with is the suggestion made by those gentlemen, and in my learned friend's case, that the average adjusting community was generally dissatisfied with the decision of the judge in this case and supported the decision of the Court of Appeal. That may be the official Richard's Hogg view, but I am instructed that there are many shades of opinion on the question of admission of negotiating period expenses, and indeed in the Marine Risk International report it is said that opinion is sharply divided within the average adjusting profession on whether a ship owner should allow.
Where is that stated?
My lord, the reference is, it's 1-2, Authorities Volume 1-2, tab 24. Does your lordship see the passage immediately below the photograph?
Who's this written by? Do we know?
The author, my lords, it's not clear who the author is. It's a report of a market seminar. So, my lord, it's recorded there that opinion is sharply divided within the average adjusting profession on whether a ship owner should alone have to bear these expenses that build up during attempts to get Somali pirates to slash their ransom demands. And, my lord, I am instructed similarly. Mr. Corner's, Mr. Tomlinson's views are emphatically not the views of, among others, Stickling Hahn Hilbrick, my client's adjusters, a major German firm of adjusters who support and advise them on this appeal. Nor is it indeed particularly the London view. Mr. Agasbury, the adjuster responsible for the adjustment in this case, is a London adjuster, and Mr. Madge, whose views you may have seen in the advisory committee's opinion, has expressed a rather more nuanced view in his dissenting opinion recorded in the advisory opinion. Now, my lords, average adjusters are in polite competition with each other for ship owners' business, and that serves to explain a slightly vainglorious press release issued by Stickling Hahn after the first instance decision, which is referred to in my learned friend's case, where, and your lordships can find that as at, I think, page 1097 of the electronic bundle, where they referred to the decision of the trial judge, or rather the approval of their adjustment by the trial judge, as overturning industry thinking and contrary to current London average adjusting practice. Well, my lords, a little bit of artistic license. Your lordships should, however, be aware that this case has some potential to cause wider disturbance, not just for the future, but also...
97's a wrong reference, I think.
I beg your pardon.
Richard Corner.
My lord, let me find the right reference.
May not matter. Find it.
1902, my lord.
1902.
Yes, 1902. It's Authorities Volume 2, Sub 3,
Yeah.
Tab 67. I beg your pardon, my lord. I've just given you, yes, I've given you a different reference. 1902. The passage I was quoting from is the last paragraph on that page.
What? Last
The judge's decision is contrary to current London average adjusting practice, has the potential to allow substantial recoveries by owners.
I see, but I thought you would, I mean, this is all, you were telling us a moment ago that they were of the opposite view.
Yes, my lord.
Well, they've expressed two opposite views then.
No, that's Stickling Hahn. Those are my clients.
This is Stickling Hahn, isn't it?
Yes, those are my clients' adjusters. Richard's Hogg standing on the other side, if you like.
So they're basically saying that theirs was a minority view which has been vindicated.
My lord, they have achieved something that other adjusters have not achieved.
Yes.
My lords, I was saying that there is some potential for wider disturbance.
If they can't agree with it amongst themselves, we better get on with deciding what the position actually is.
My lord, that was going to be my next submission to your lordship. I think it's right, though, that I should tell your lordship that if we are right in our arguments, there will undoubtedly be adjustments, either published or unpublished, but waiting the decision in this case, where allowance has not been made for negotiating period expenses, and there will therefore have to be some further work done if I'm right. And there may be a degree to which different average adjusters are, if you like, invested already in one view or another. I cannot, of course, say which average adjusters are so invested. But what I do say is that because of Mr. Corner's original involvement in this case, he and RHL and their views, they are to some extent party pre in defending the reasoning, not the reasoning, in defending the result suggested originally by the majority of the advisory committee. And so I do invite your lordships to give no weight to that material other than as argument. Since my learned friend has seen fit to refer to the Stickling Hahn press release, which I've just shown you, let me tweak his tail a little and show you the RHL press release issued after the Court of Appeal decision in this case. And this is page...
Does this really help us?
My lord, I'm going to, yes, my lord, for
Right,
one line.
if you say it.
For one line only.
Right.
If your lordship looks at page 1910
Yep.
in the electronic bundle, volume 2, sub 3,
Yep.
Mr. Corner has expressed his views here
Which
in this
flag is
article
that?
on the decision of the Court of Appeal.
Very last page, I think.
I just wish to pick up one sentence. 1910.
Yep, very last page. Yep.
Practitioners may feel that the decision on issue 2 is inconsistent with the comments made regarding issue 1, but in absolute terms, quick payment of a first ransom demand to recover ship and cargo while minimizing the period of danger to both is impossible to argue against. That, my lords, is a thought that has inspired us in this
Nonetheless, he
case.
says it would have been very controversial. So, I mean,
My lords, the Court of Appeal referred to the views of the advisory committee in this case, that negotiation period expenses should not be allowed, as representing a respected professional view. My lords, that may be right, although we have throughout challenged its legal coherence. There are other respectable professional views, including in other legal systems, and I'm therefore going to show you, as the last of my preliminary comments, an extract from the Spanish Commercial Code of 1829, which was in force until 2 or 3 years ago, and which your lordships will find at volume 2-3 of the Authorities Bundle, tab 65, page 1893 in the electronic version. I'm showing you this in the English translation. My reference is to Article 811 of this code, 1893. As a general rule, general or gross averages shall be all damages and expenses that are deliberately incurred to save the ship, her cargo, or both, from a known effective risk, and in particular the following, and then your lordships may go down to subparagraph 9.
Yes.
The salaries of any member of the crew taken hostage by enemies, privateers, or pirates, and the necessary expenses arising from his imprisonment until returned to the ship or home if he prefers. My lords, I don't suggest that that helps you at all, save to correct the impression that there is only one respectable view here. National law on these matters is now almost entirely irrelevant, so far at least as the carriage of goods is concerned. The whole territory has been occupied by the York-Antwerp rules to the exclusion of national law since at latest 1950, and so we should look at those rules. But my lords, before I address the decision of the Court of Appeal directly, can I observe that this is a case where the issues have appeared to multiply rather than diminish as it has moved through appellate stages. And I have to keep reminding myself, as I did the Court of Appeal, of how this case started out. It started out as a single issue case. Just to run through the chronology, the adjustment was published on the 31st of August, allowing the negotiation period expenses under Rule F. For your reference, the adjustment is in the core bundle at tab 8, subtab 5, page 246, and the relevant adjuster's note on Rule F is at page 253. It's adjuster's note 09. Now, almost a year later, on the 21st of June...
Let's go back to
my lord.
the Spanish thing.
Yes, my lord.
We've only got one foreign law, but you can't be suggesting that that is the position under the York-Antwerp rules.
No, my lord.
No.
No, my lord.
Otherwise, I mean, irrelevant of whether there were negotiations, supposing that the pirates just disappeared with the ship and crew, you would recover crew wages during that period.
My lord, quite so. The York-Antwerp rules proceed in an entirely different way, on the basis of substitution, we would say, it belongs to a different era in general average when things were much more prescriptive. The York-Antwerp rules, at least in their lettered rules, provide general principles, but old codes of national law were much more prescriptive and gave numerous examples of when general average might be recovered.
Well, they were developed, the general average rules, under the auspices of what you incorrectly call the International Law Society. It should be the International Law Association.
In
a footnote
right.
In 1890 and
Yes.
revised in 1924.
Yes, and indeed Rule F is the inspiration of the French branch of that association.
So all this is old hat and we don't need to worry about
My lord, I deploy it only to show that there are other respectable views under other legal systems to show that the costs of paying...
it. Yeah, but we're only interested in the York-Antwerp rule.
Quite so. My lord, can I just briefly go back to the chronology of this case? The adjustment is the 31st of August 2011. The relevant note, my lords, I think I was giving you Adjuster's Note 09 on page 253. Almost a year later, the Advisory Committee published its majority opinion. My lords, that is in core tab 8, subtab 7, page 423. They were of the opinion that none of the negotiation period expenses were allowable. And I should show you, your lordships, the reasoning there. As I say, it is in Core 8, sub-tab 7, page 423, but I think I can ask your lordships to look at page 426. And I read, the original rationale, I'm picking it up in the third paragraph on that page, the original rationale was that the detention costs during the period of negotiation leading to the actual settlement should be treated as having been substituted for the reduction in the ransom demand achieved by the period of that negotiation. The difficulty with this suggested reasoning is that if the ransom ultimately agreed and paid is treated as the reasonable amount to have paid, then by definition any greater amount, even if settled earlier, must be regarded as unreasonable to the extent that it exceeds the amount actually settled. Thus there can be no excess which can constitute savings against which the putative substituted expenses can be allowed in general average. It is noted that Mr. Madge advised that he was in agreement in principle with David Clancy's premise that only when the negotiations reach a point where the requested ransom should be considered reasonable could any argument for a substituted expense start, and this appears to be a concession that the original adjustment was incorrect. Well, my lords, that depends on the width of any latitude to be afforded to the concept of reasonableness. He then goes on to identify the difficulty of deciding at what point in the negotiations a reasonable amount would have been reached. The panel didn't find this to be difficulty at all. That point is reached when the negotiation arrives at a figure which is at once the highest amount the owners are prepared to pay and the lowest amount that the pirates are prepared to accept. It is, in short, the amount for which the ransom was actually settled. In the circumstances, there can be no savings against which any detention or other costs during the negotiation can be allowed as substituted expenses. So that's the reasoning of the advisory committee. On the back of that, the respondents issued proceedings over a year later, on the 24th of September 2013, reclaiming repayment of contribution allegedly overpaid on account. And my lords, the case pleaded was that in breach of contract, general average had not been properly adjusted in accordance with the rules because the negotiation expenses should not have been allowed as substituted expenses under Rule F, it was said that payment of the initially demanded ransom without attempting to negotiate would be unreasonable. And that's paragraphs 22 to 23 of the particulars of claim, which your lordships do have in the core bundle at tab 11, 465 to 466. Now, the appellant's defence first attempted to justify the negotiation period expenses as allowable under Rule A. Can I just ask your lordships to see the defence? It is in core 8 sub 12 at 4, and the relevant passage is at 472 to 473. On this page, my lord, it is paragraph 13 sub 3, dealing with, first of all, with the assertion that all these sums were recoverable under Rule A. The defendants will say that the said amounts, and each of them are allowable under the general average, in general average pursuant to Rule A, since they're intentionally and reasonably made or incurred for the safety. But then, my lord, this is where we put the Rule F point. Alternatively, the defendants will say that the said amounts and each of them are allowable in general average pursuant to Rule F, since, among other things, the said amount were incurred to reduce and did reduce the amount of the ransom paid by the pirates, and in the circumstances, the said amounts and each of them were incurred in substitution for general average expenditure, since, among other things, payment of ransom in the amount initially demanded by the pirates would have been reasonable. And then a submission which was developed in our skeleton argument for the trial. In this connection, assessing reasonableness must proceed on the hypothetical assumption that the alternative course, i.e. to negotiate the amount down, was not an available option. That is a submission which is one of our answers to issue 2, but there are others. Now, my lords, in their reply, which is the next tab in this bundle, and I need to just show your lordships, page 480, the respondents specifically relied on the publication by the advisory committee of an opinion that wages and maintenance of crew and consumptions of bunkers during the period of piratical detention are not allowable in general average. That is at paragraph 4 of the reply. I think it is technically in response to the assertion of allowance under Rule A, but, well, it also provides an answer under Rule F.
Yeah.
And, my lords, the case as pleaded was therefore perceived as one of principle. Was it right to say that payment of the initially demanded ransom of 6 million would have been unreasonable, what we now identify as issue 2 in this case? But notice that the respondent's position was that none of the relevant expenses were allowable, and they had referred specifically to the opinion of the advisory committee that no wages, maintenance, bunker consumptions were allowable. There was no concession made to the point by Mr. Madge, which your lordships have seen referred to, the dissentient on the advisory committee, who posed the question at what stage in the negotiations, at what level of ransom demand, would it have become reasonable to pay the pirates? Because implicitly from that point onwards, further negotiation period expenses would become substitute expenses in substitution for a reasonable general average payment. So far as the pleadings were concerned, this was therefore a single issue case, and what was centrally an issue was the correctness of the opinion of the advisory committee. And my learned friend says in his case, at paragraph 106, in truth, the trial was framed as giving rise to an issue of law. Well, law, or shall we say evaluation of facts against a legal standard. And on that basis, as Lord Justice Hamlin observed in the Court of Appeal, the case was approached very economically, without disclosure, without expert evidence, in anticipation of a one-day trial on documents and written witness statements, with junior counsel instructed on both sides. The case management order, should you wish to look at it, is in the additional volume, tab 4, page 564. It was an unusual commercial court case in which the parties were content to proceed to the issue of principle that appeared to divide them. Now, at trial, the respondents took the liberty of adding 2 unpleaded issues on Rule F. Firstly, whether the expenses were extra expenses for the purposes of that rule, and whether the consumption of bunkers was expenditure. Rule F deals only with expenditure. But the principal issue on Rule F remained the reasonableness of paying the first demanded ransom sum and the correctness of the opinion of the advisory committee, whether payment of whether the only ransom that would have been reasonable to pay was that which was ultimately agreed and paid.
What was the first new issue you say they added at trial?
There are 2 issues added at trial, whether the expenses were extra expenses within the meaning of Rule F, and the other one was whether the consumption of bunkers was expenditure. We will come to that. Those appeared to be the pleaded issues. Now, and one can see that by reference to the respondent's skeleton argument at trial, which I do ask your lordships to look at. It's in the additional volume, tab 5, at page 589. That's the electronic reference. And can I pick it up at paragraph 77 on that page? The simple question that has to be answered by the court, free of any assumptions.
I'm so sorry, paragraph?
I beg your pardon, it's 77. 77, page 589.
Yes, I have it. Thank you.
The simple question that has to be answered by the court, free of any assumptions, is would the payment by the shipowner of the first demand made by the pirates in the amount of 6 million without any attempt to negotiate be reasonable on the facts of this case? That's what we call issue 2 now. If yes, subject to the further points below, the defendant's defence succeeds. If no, the defendant's defence fails. And then if your Lordship proceeds to paragraph 80, it is submitted that the payment of the initial demand was not reasonable, and indeed the only reasonable course of action was to negotiate to a lower price. And then various points are made, including, if your Lordship turns over the page 590, your Lordships will see at 80.5, reference to and reliance upon the report of the Association of Average Adjusters, and at 80.6, by way of fallback, reference to the opinion of Mr. Madge. Now, my Lords, pausing there, I must also ask you to notice paragraph 81 on page 591.
Yep.
This analysis further confirms that Rule F can have no application to a case where a particular type of expense is not avoided in preference to a different, brackets, cheaper type of expense, namely the types of scenarios set out by Lowndes, page 181. My Lords, I don't ask your Lordships to look at that page now. For your reference, it is Electronic Bundle Reference 1073. But rather there is a period of delay whilst a particular type of expenditure, a ransom payment, is reduced in amount so as to reach a point at which the paying party can conclude the amount paid is a reasonable amount and can therefore be legitimately sought from the other parties. Now, my Lords, that is the
definition of a reasonable amount. Is it any amount which the parties are willing to agree, or what?
My Lord, we say that the issue in relation to reasonableness, as it arises in connection with Rule F, it arises in connection with Rule F because one has to incur the substituted expenses in substitution for, in place of, allowable expenses. And allowable takes you to another rule where those avoided expenses may be allowable. The reference to another rule can be a reference to a rule that allows reasonable expenses, such as under Rule A, or it can be a reference to another rule where the touchstone, if you like, of allowability, for want of a better word, is necessity. But either way, there has to be an allowable avoided expense. And we say that the answer to what is reasonable in that context, if reasonableness is the touchstone, has to take its context from Rule F, and that involves, my Lord, I'm not going to be able to do this quickly, consideration of what we have called the Hudson Conundrum. Now, the Hudson Conundrum is dealt with in our case.
My Lords, I hesitate to interrupt, but I know a friend may be moving on from this document you've been looking at. I just wanted to show you two other passages in it, which is the skeleton at first instance. Page 583, paragraph 51.
I'm coming back to that.
Yep.
I know a friend tells me he's coming back to it. It's just to make clear that at 51.1, the in place of argument was clearly put first time round. And we see something of a similar flavour at paragraph 91. I wasn't going to say any more than that, but I didn't want the impression given that the point issue 1 was not live before the judge.
Thank you. Yep.
My Lord, we deal with the Hudson Conundrum in footnote 75 on it's electronic bundle 109. And the essence of the conundrum is this: how can the avoided course of action be considered a reasonable one so as to be allowable under Rule A if the course of action actually taken in its place was obviously the more economical one? The more obvious it is that the course actually taken was the reasonable one to take, the less likely it is that the avoided course could also be considered reasonable or allowable, if that's how it works. And the less likely, therefore, that the costs of the course actually taken will be allowed under Rule F. It's a course of reasoning that Mr. Hudson, who first identified it.
It's a Hudson paradox, really.
My lord? I forget.
Paradox, really.
It's a paradox or a circularity. Well, he described it as a circular and self-defeating. My lord, the conundrum arose in exactly the same way in the Bigella, but in a more acute form, because the touchstone there of allowability under Rule 14, as it was there, took one to Rule 10b, which required necessary expenditure avoided. And that raised the conundrum of how could expenditure that was necessary have been avoided. That is, if you like, the paradox or the Hudson conundrum. And it creates difficulties for substituted expenses where the rule of substitution makes reference to allowability under a different rule. Now, my lords, I was showing your lordships paragraph 81, I beg your pardon, paragraph 81 in my learned friend's skeleton argument at trial, and I'd just remind you that paragraph 78, the issue was put simply in terms of reasonableness. The issue we now call issue 2. But at 81, there is a slender thread of a reference to a case where a particular type of expense is not avoided in preference to a cheaper type of expense. And we think that that is what allowed issue 1, if you like, into play as one of the further points detailed below referred to in paragraph 78. So that was what allowed issue 1 in play. The learned judge plainly did not understand that separate issue to be presented to him. But the suggestion made in 81 is that Rule F only operates where the substituted expenses are of a different type of expense to that avoided, and that point had in fact been trailed, as my friend quite rightly says, further up in paragraphs 51, and in particular paragraph 54, this is on page 584 of the bundle. This is the paragraph that was picked up by my Lord Justice Hamlin in the Court of Appeal as showing that issue 1 had been in play before the judge. And paragraph 54 says this: Lowndes describes substituted expenses as substituted expenses incurred in respect of a course of action undertaken as an alternative to or in substitution for the expense of an action that would be allowable as general average. Examples at page 181 of Lowndes. It is submitted that none of these examples are comparable to the instant case in that they represent truly alternative courses of action by which expenditure different in kind is incurred. And that is what my Lord Justice Hamlin picked up in the Court of Appeal and, as we say, ran with. But, my lords, the judge didn't see that point separately, and we rather suggest, in light of the way matters were put in the skeleton argument, at paragraph 78, he can be forgiven for not having dealt separately with that point. So those are
the general idea behind all the specific examples given in Lowndes is that in the face of a casualty, there would be ways in which the venture could be completed in the originally contemplated manner.
Yeah.
Permanent repairs, all the delay, attendant, and so on. But there may be some completely or very different action which could be taken, which wouldn't normally be within the ordinary venture at all, such as getting the vessel towed
Yes.
instead of repaired, or having temporary repairs done, or indeed selling the cargo and then buying in further cargo, which is pretty extraordinary.
That one is no longer allowed under the rules.
Right. All right. Well, so, I mean, if you look at the sort of genus of the specific examples where we can accept that Rule F applies,
Yes.
they all contemplate some usual way of dealing with the casualty, namely repairing the ship and getting on with the original voyage. But
Yes.
they also say, well, if you're inventive, there may be some lateral thinking which enables you to step out, or involves stepping outside the original, what would originally be permitted. And you can, in many cases, stepping outside what would originally be permitted, and you can then mitigate the loss if you're allowed to do that. Whereas here, what we have is basically a larger sum is substituted by a smaller sum, with
Yes.
some attendant delay
some
on the
expense.
way. It isn't a sort of different type of expense at all. It's just obviously reducing the amount you have to pay to get the ship free.
Well, the question...
May that be a problem for your case?
The question your lordships will have to consider is whether it is important for Rule F, and looking closely at its words,
Yes.
that the type of...
The basic type of substitute expense is a different sort.
Well, the substituted expense, bear in mind, is the expenditure of keeping the vessel
No, the
going.
substitute, the prima facie substitute expense is paying a lesser sum instead of a larger one. And you're relying on the ancillary, what you say is an ancillary substitute, additional substitute expense, namely the cost of delay.
You would say the expense that you're saving is the difference between what you paid and what you would have had to pay.
Yes. That is, if you like,
another expense.
the saving of allowable expense is the difference between the first ransom demand and that which was paid. Now, in order just to get the, if you like, the terminology right, the substituted expense is the expense actually incurred in order to achieve or to achieve that result.
Yes, and you say it's the lesser sum paid for ransom plus
The substituted expenses, my lord, are the negotiating period expenses, the wages, crew, high-risk area bonuses, and bunker consumptions.
You don't say the smaller sum you
That
pay
is-
by way of ransom comes into it at all. You say the another expense is simply the difference between the sum you had to pay and the sum you would have had to pay if you hadn't negotiated.
One has to look quite closely at the way in which the rule works. The substituted expenses are what are called the extra expenses incurred.
Yeah.
And those are allowed where they are incurred in place of another allowable expense,
Yes.
but only up to the saving in allowable expense.
Yes, quite.
So the substituted expenses are the extra expenses. That's the wages and bunker consumptions we're concerned with. The avoided expense is the payment of the first ransom, and the saving in allowable expense is the difference between the first and the final ransom demand.
Yeah.
Yeah. So, my lords, I've shown your lordship the arguments that were in play before the judge, and save for what might be called the true alternative course of action reasoning referred to in paragraph 54 of the skeleton argument at trial, he dealt with them. He dealt with them all, and he also dealt with a cognate point that the expenses were not incurred in place of a ransom payment, but rather in addition. to the payment of a ransom payment. That was a point that was addressed and dealt with at paragraph 94 of his judgment, by Lords 241 of the core bundle. Let's look at that very quickly. The claimant's first contention is that Rule F is not engaged because the expenditure which has been allowed in the adjustment was not incurred in place of the expense of a ransom.
Sorry, which page were you on? Sorry.
My Lord, is page 241 of the core bundle.
Yeah, thank you.
Paragraph 94 of the judge's judgment.
Yeah.
And the contention he's dealing with is that that Rule F is not engaged because the expenditure which has been allowed in the adjustment was not incurred in place of the expense of a ransom payment, but rather in addition to the expense of a ransom payment. This contention can be dealt with shortly. There can be no doubt that the expenditure was incurred in substitution for the saving in ransom, i.e. the difference between the ransom initially demanded and the ransom ultimately paid.
Is that what Rule F means? I mean, expense incurred in place of another expense which would have been allowable as general average.
Yes.
Surely the other expense which would have been allowable in general average is not the saving, it is the whole of the 6 million.
It's fair to say that the learned judge slightly compressed Rule F there, in that he referred to the saving rather than the way Rule F works is to look at the substituted expenses, the allowable expense avoided, and then the saving in allowable expense, because that provides a limit on the allowance of substituted or extra expense.
Yeah, I mean, again, I put to you that the extra expense incurred is in fact surely, on your case, both the ultimate 1.85 million paid as ransom and the delay costs.
No, my lord.
You can only recover up to the amount of the 6 million.
My lord, the way it works and has been put consistently is that the extra expense is the additional costs of maintaining and running the vessel while the financial negotiation is going on. That's the extra expense. And what is that incurred in place of? It is incurred in place of paying the sum initially demanded, and the relevant saving, which would provide a limit on the admission of the extra expenses, is the difference between the first and the final.
Well, I see that's the way you put it, but up to the amount of the general average expense avoided is surely the whole of the original expense which would have been allowable in general average. In other words, there's 6 million. It's not the difference between 6 million and 1.85 million.
No, the difference provides simply the limit on the admission of...
It only provides the limit if you include in extra expense the 1.85 million, as well as, on your case, the delay costs.
Oh yes, my lord, I say the avoided expense is 6 million.
Yes, and that's the amount of the general average expense avoided, yes. So,
yes.
So that you can recover extra expense, namely the 1.85 million, I'm putting to you.
No, that's not avoided expense. That is allowable under...
Well, no, it's incurred expense. That's why it's recoverable under F.
It's a ransom payment, my lord.
On your case.
1.85 is a ransom payment, and that is allowable under Rule A.
I see.
It's not, doesn't depend. The ransom actually paid in the end is an expense allowable under another rule.
I see. Well, if that's so,
Rule A.
it may create a slight extra difficulty in fitting this within Rule 5, as it seems to me. And I see why you say it's recoverable under Rule A.
Yes.
On that basis, we'll hear your argument.
Well, there we are. Let's see if I can make it good in due course. I'm sorry, I've been slightly sidetracked. So, my lord, those are the arguments before the judge, and they were, in effect, with the addition of issue 1, the grounds of argument eventually in play before the Court of Appeal, after the court had given such permission as it did to amend the grounds of appeal. The essential point, as I say, before the judge, was that this was a case prepared for trial, framed as giving rise to a single issue of law, or, as we would say, evaluation of the facts against a single legal standard. And although other issues of law on the scope of Rule F were allowed in at skeleton argument stage, they were all points of principle and construction in relation to that rule, as the judge said in his judgment, paragraph 68. As to what was in play before the Court of Appeal, can I show you the amended grounds there?
But what's the significance of all this? I mean,
My
going
Lord,
into the history of it all,
your Lordship knows we have an objection, and I hope your Lordships have received a note of objection to a very large number of additional points that are suddenly deployed in my learned friend's case without prior notice. And we are concerned by that because it means that I'm going to have to address orally a great number of new points that are not dealt with in my case and have never been considered by any of the courts below. That's the point of this history. I wanted to show your Lordships the grounds of appeal in the Court of Appeal.
Well, I mean, as I recall it, in the Court of Appeal, you raised a point that you hadn't raised before and you were allowed to raise it, or the other
No, it's the other way round.
The other side, but I mean, they took the view that there was no prejudice.
The Court of Appeal said it was an issue of law.
Why isn't that the right approach for us to take?
I'm not complaining about the issue of law that they successfully introduced,
Right.
but I am going to show you some grounds that were
these are yet further
not
new
introduced.
offensive points.
Yes,
Yeah.
my Lord.
Well,
These
my,
are.
my point is really that if they don't put you in embarrassment for not having been raised at first instance, is there really much of an
My
objection
Lord-
to us considering them now? And if they do, then I understand.
Well, there's a great deal of difficulty in dealing with a whole lot of new points which have never been addressed, and your Lordship will get no assistance from the judgments below. And the only assistance your Lordships will get is in oral argument, because they're not addressed in the cases either.
Right.
And this is a very awkward state of affairs. Now, I'm going to show your Lordships, and then I'm getting to the point. I'm going to show your Lordships the grounds of appeal in the Court of Appeal, additional volume, tab 3, page 554. Now, your Lordships may wish to mark or note in some way the extent to which these amended grounds of appeal were allowed by the Court of Appeal. Sorry, this is additional volume, tab 3, page 554 in the electronic version. Ground 1.1, the extent to which this was allowed was the first sentence. He ought not to have concluded that the expenses were incurred in adopting a course of action as an alternative to or in substitution for one where the expenses would have been allowable as general average. That was the extent to which that ground was allowed.
Thank you.
Ground 1.2 over the page is a challenge on the basis of something called Rule C of the rules, that the substituted expenses was not a direct consequence of a general average act and shouldn't therefore have been allowed. That was withdrawn.
Right.
And I'm highlighting that because a new argument on Rule C is now being advanced in the written case. And then 1.3, just below that, he ought to have found that the substituted expenditure was not incurred in place of another expenditure, in that both the actual and the alleged hypothetical course of action involved the incurring of crewing and bunker costs and the payment of a ransom, basically saying it's the same sort of expense. But what follows, and that it has not been demonstrated that there has been a saving by reason of the substituted expenditure, that was withdrawn and as unnecessary and was not therefore part of the grounds before the Court of Appeal. And therefore next 1.4 a ground of appeal that he ought to have found that by reason of the matters set out in 3 above, the substituted expenses were not extra expenses within the meaning of Rule F. That was also withdrawn, was not the subject of any decision by the Court of Appeal. Your Lordships will find a similar submission being made in the written case. And then the rest of the amendment...
Got a paragraph reference for that.
Oh, my Lord.
Give it.
In the written case? Yes, my Lord, let me just find that. Um, 148.2.
Yep.
So your Lordships should have identified there how much of the amended grounds went before the Court of Appeal and were the subject of their decision, and how much was withdrawn. I should identify on pages 557 and 558 further amendments to the draft grounds of appeal. Those were all allowed. But I'm anxious to identify those points that were withdrawn from the Court of Appeal. Now, my Lords, in the notice of appeal and the respondent's notice, or rather respondent's notice of objection, we seem to have distilled matters down into issues 1 and issues 2, as set out in the agreed statement of facts and issues, page 49 of the core bundle. My Lords, yes, the issues are at page 66 of the core bundle. As to the grounds of challenge to the Court of Appeal's decision, our grounds are, of course, set out in the notice of appeal, pages 18 to 23 of the core bundle, and equally, naturally, they are confined to grounds of challenge to the reasoning on issue 1, issue 2 having been determined in our favour. And then the respondents filed a notice of objection at paragraphs 40 to 48 of which they identified 4 different grounds on which they said the order of the Court of Appeal would be upheld, or they would seek to argue that the order of the Court of Appeal should be upheld, and those 4 grounds are expressly confined to issue 2. My Lords, for your reference, it might be useful to look at it. This is in the core bundle at tab 2, page 37 and 38. Where you see the order should be upheld on different grounds, and then, well, 4 separate grounds are identified focusing on issue 2. No grounds seeking to uphold the Court of Appeal on issue 1. So that's where we stood. We'll call those the notified grounds, and that was the basis on which we prepared our written case. So, my Lords, it was dismaying to discover, merged in and pervading my learned friend's written case, a very large number of new, previously unnotified grounds for sustaining the Court of Appeal's decision on issue 1, and indeed some new points not previously notified on issue 2. These are grounds which formed no part of the reasoning of the Court of Appeal itself or of the judge, and find no mention in that notice of objection. They are grounds which have not been addressed at all in my case, which had to be served first, and that is more than a little unsatisfactory. My learned friend can point to Rule 25.1 of the Supreme Court Rules 2009, which specifies rather surprisingly to us, it's under a rule which is headed cross appeals. And it says this: a respondent who wishes to argue that the order appealed from should be upheld on grounds different from those relied on by the court below must state that clearly in the respondent's written case, but need not cross appeal. So that appears to, if you like, dispense with a respondent's notice procedure. It is sufficient to identify different grounds for upholding a decision, from those relied upon by the court below in the written case. But, my lords, we have studied my friend's written case. We can find no clear statement, as is required, that he seeks to uphold the order appealed from on grounds different from those relied on by the court below. What one has to do is to wade through the written case, line by line, and identify to what extent the arguments there do or do not reflect the argument or the reasoning of the court below. And it may not, therefore, have been very obvious to your lordships, on reading the written case, that in fact very many of my learned friend's arguments are entirely new to this litigation. And it is, perhaps self-evident that everything they had to say on issue 2 was different from what was said or relied on by the court below, because on issue 2 the Court of Appeal was with us, and therefore anything he might be saying to challenge that conclusion was within the rubric of 25.1. But as for issue 1, and indeed issue 2, there is a great deal that is new to this litigation.
I'm trying to look up the rules, I'm afraid to say it's...
My lords, we have
I've got the
copies.
same problem.
So there's a problem with the,
Mine too.
It may be,
with this website's security, sir.
my friend, my junior, has copied the relevant sections, and it may be helpful just to hand these up.
But I think, I mean, the 2 points you're raising, one is he hasn't clarified in his notice what he's talking about, that he is effectively trying to cross-appeal. The other is the scope of Rule 25.1, which, subject to hearing further, may well be limited to issues which are open below.
My lord, I'll come to the next point, if I may, because there is a practice direction as well.
I think we've had this problem recently, and
Yes.
we've actually, I think, ruled on it.
Yeah, well, I'm interested to hear that. The fact that there is no respondent's notice procedure in this court is quite understandable. One would expect the points to have been refined and distilled by the time they reach this place. But in fact, the opposite is happening here. Can I now ask your lordships just to look, since you have them now, to Practice Direction 6, para 6.3.3. No, have you not? No, they've all gone up there.
No,
My Lord, Practice Direction 6.6, paragraph 6.3.3. If either party is abandoning any point taken in the courts below, that should be made plain in its case. If they intend to apply in the course of the hearing for permission to introduce a new point not taken below, this should also be indicated in their case and the registrar informed. Now, my lords, there is in my learned friend's case no indication of an intention to apply to take points not taken below, although undoubtedly he seeks to do so. And there has been, as far as I'm aware, no indication to the registrar of that intention. Now, my lords, the reason this is important is because it is potentially very expansive of the oral argument. Because I have to address these points now orally, and that places me under some considerable time pressure in keeping to what is my agreed 3-hour time window. I will endeavour to keep to it, but I am presently struggling. In the absence of a clear statement in the written case that the order appealed against should be upheld on grounds different from those relied on by the court below, and in the absence of any application notified in the case to introduce new points argued below, not argued below, my position has to be that my learned friend is confined to seeking to uphold the reasoning of the Court of Appeal on its reasoning. That's an overarching submission. I will identify what I submit are new arguments in the course of my further submissions. But I can make this perhaps rather obvious point that my learned friend's attempt to uphold the decision of the Court of Appeal on issue 1 on grounds not expressed in the Court of Appeal's judgment has some eloquence of its own. Let me turn to issue 1. We confess to having found some difficulty in discerning the true ratio of the case in the Court of Appeal. We've set out what we understand to be the position in our case at paragraph 43. That's page 85 of the electronic bundle. There seem to be two strands of reasoning. The first is this, that in order for Rule F to be engaged, there has to have been what is described as a real choice between the courses of action open to my clients, and that the evidence did not suggest to the Court of Appeal that the owners considered themselves as facing and making any such choice. And I'll call that, if you like, the real choice argument.
Okay.
But there is a further strand in the reasoning, which is derived from paragraph 54 of the skeleton argument I was showing your lordships, and that is this, that in order for Rule F to be engaged, the alternative courses of action had to be described as true alternatives, that is to say, different in kind and nature from each other, or perhaps that the expenditures involved in the two alternatives had to be different in nature and kind and not merely in degree. And I'm going to call that the true alternative argument. Now, my lords, we explore this in our case, paragraph 45, and this is a convenient point to show your lordships the passages in the judgment dealing with issue 1. This is at page 210 and following of the core bundle. And I pick it up at paragraph 38 on page 210.
Yep.
The reference to an alternative course, we accept that it's necessary for Rule F to operate, that there should have been an alternative course of action, reflects the fact that substitute expenses have to be in place of another expense. That implies a choice being taken between two or more alternative courses of action. And then there is reference at paragraphs 41 and 42 to the cargo interests, my learned friends' contentions, and on inspection, your lordships will see that those are put in terms of no true alternative. The moment that the Somali pirates took control over the vessel, and even prior to a ransom demand being made, the owners were involved in a negotiation for the release of the vessel. And then paragraph 44, just in the final sentence of that paragraph, whether the negotiation is short or long, the owners will in both situations incur crewing expenses, and the vessel will consume bunkers by reason of the hijacking, and will ultimately, upon conclusion of the negotiations, pay a ransom. That also is put in terms of no true alternative. And if I can go to paragraph 43, some support for the cargo interests approach is to be found in the evidence, and here my Lord Justice Hamlin develops no real choice. It does not appear that the owners ever considered that they faced a choice. The owners' crisis management team were set up before any ransom demand had been made. We challenge that. From the outset, the goal was to negotiate to obtain release of the vessel upon payment of a ransom in a reduced amount. We don't think that's right. There's no evidence to suggest that they ever considered choosing between paying the ransom on demand and paying a lesser sum following negotiation. All of that is put in terms of choice. And then there is a reference to the advisory committee's stated experience, and at the bottom of paragraph 44, it does not appear there is considered to be a choice of payment on demand. And then the critical, as we would say, paragraph 45, in my judgment, this failure to recognise that there is a choice reflects the reality, which is that payment on demand is simply a different way of going about the same course of action and not a true alternative course of action. So now we are reverting to true alternative. Whether or not the ransom is paid on demand, there will still be a negotiation, there will still be delay, there will still be the incurring of vessel, and I should insert there some vessel and crewing costs during the course of the delay. In either case, the same expenses, I think he must mean the same sort of expenses, will be incurred. The difference is only in their extent. So that is paragraph 45.
Is it your submission that that is an error of law in that alternative courses of action may go not only to different types of action,
Yes.
but to the same type of action conducted in a different way with potentially different results as to other recoverable expense?
Your Lordship has encapsulated one of my main submissions, yes. We do say that, and we say that if you look at Rule F, there is no justification for any analysis other than whether one course of expense has been incurred in place of another course of expense. There's no requirement at all that they should be different in character or kind or degree or anything.
Is this a question which has ever given rise to discussion in the authorities?
No. There is no support in any textbook for what appears to be the superadded requirement found by the Court of Appeal of difference in character or kind.
No support and no contradiction?
My Lord, it's fair to say no contradiction either.
But your simple point is that this is adding something to Rule F.
Yes. Yes, that's entirely right. Now, I just want to complete the exercise of going through the judgment, can I ask your Lordships to look down to paragraph 49?
Yep.
Because this is important in many ways for us. Although nobody appears to have considered it to be an option at the time, it is correct that the owners could have agreed to pay the initial ransom demand, and if the parents had agreed to that, release of the vessel would have followed in due course, and this could be regarded as an option that was available to owners. But then the learned judge goes on. That does not, however, address the issue of whether it is an option to take a course of action which is a true alternative to that actually taken. Is a short negotiation with pirates for payment of ransom, leading to the release of the vessel, a different course of action to a long negotiation with the pirates to the same ends? In my judgment, it is not. Both fundamentally involve doing the same thing. This is to be contrasted, for example, to a clear alternative, and he refers to regaining control of the vessel by force. So, my lords, at that point, it rather appears that the learned judge is adhering to a line of argument of no true alternative.
I find myself in difficulty in getting into the right frame of mind to address these paragraphs, because I think on your case, now I see how the way you put it under Rule F, on your case, the extra expense is simply the delay costs, crew
Yes.
and so on, whereas the alternative has nothing to do with delay costs. The alternative is of a different kind, namely, it is the paying of the excess ransom, i.e. the 4.15 million,
Yes.
over and above what was actually ultimately paid. And those are different things.
That's the
Paying
same.
a ransom sum is a different thing from incurring an expense by delay.
Absolutely.
So why are we in this argument?
Why are we in this area?
I mean,
at all?
I don't
Yeah.
quite see how. I mean, maybe the Court of Appeal is analysing it in the way that I originally was analysing it.
Yeah. Yes. Yeah. Well, your lordship has this point. There is no.
Well, surely the comparison is not between the expenses actually incurred and the expenses which would have been incurred, but whether the courses of action that lead to those two results are themselves different. So one isn't comparing the cost of paying the crew, etc., with the cost of paying the ransom. One is comparing course A, which is to pay a higher ransom earlier, and course B, which is to pay a lower ransom later.
Yes.
Now, on the face of it, if there is a rule such as Lord Justice Hamlin was suggesting in paragraph 45, that the two courses have to be of a different nature and not the same course to a different degree, then you are in some difficulties. If there is no such rule,
If there is no such rule,
then you win.
yes. Your Lordship has it, and the reference to courses of action is wrong, is misleading. There is no
You say it
reference.
simply adds something, it simply cuts, it implied cutting down of Rule F.
Yes,
which is
he's
nowhere
glossed
to be
it.
found in the words.
He's glossed it to find additional requirements which are simply not in the rule.
Yeah.
Now, my lords, I was showing you the strands of reasoning, and if we get as far as paragraph 49, it is pretty clearly no true alternative reasoning. And then if we go to paragraph 50 in the judgment, there's a suggestion that the judge didn't address the issue, and then just opposite C in this report, he did not, however, address the argument at paragraph 54 of the cargo interest skeleton argument that none of the textbook examples of substitute expense are comparable to the instant case in that they represent alternative courses of action.
Truly alternative.
Truly
It's the
alternative, forgive
same
me.
point, yeah.
It's the same point.
Yep,
This
yep.
is all
Yep.
true alternative.
Yep.
And then if we go to 51, here's my slight difficulty, if I may say so. We go through 51 where there is a discussion of equity and natural justice, fair apportionment of benefit and costs. Generally, there is no recovery in general average for ordinary expenditure under Rule A or for loss of damage sustained through delay.
Yeah.
Delay will often cause loss to both ship and cargo, but generally that loss lies where it falls. Then he goes on, rather importantly, whilst such owner's expenses may on occasion be recoverable under Rule F, that rule presupposes some real choice being made, which it was not. So suddenly we get real choice reasoning coming back in as a...
But is real choice another way of putting the same point? Is choice between two, what he would call two real alternatives?
Well, it may be, my lord, but the way in which it appears from the earlier sections of the judgment, it appears to be some reference to a requirement of, if you like, actual cogitation on the part of my clients that they...
There appears to be a suggestion that the alternative courses must not simply be available in an abstract sense. There must be some agonizing.
Yes.
Can I ask, what about the core part of this paragraph? Further, the expenses claimed are ordinary operating expenses incurred by reason of delay.
Yes.
And, I mean, in a sense, the costs of running the ship and paying the crew are expenses which you had no choice but to incur. If the ship had been released, you would have been incurring them. Your real complaint is that you've not been earning freight. I assume you may have been, for all we know. It may still have been on hire while it was in the pirates' possession. If it wasn't on hire, then no doubt you can have some sort of insurance which covers you for less hire due to this sort of event. Is this another angle on what the Court of Appeal was thinking about?
I don't believe so, my lord, because the one thing that was clear from the judgment below, and it wasn't ultimately appealed, was that these expenses qualified as extra expenses for the purposes of the rule. That was not challenged in the Court of Appeal. Now, extra in our submission means only this. These have to be voyage expenses additional to those which would have been pre-contemplated as the expenses of the voyage.
Which would have actually been incurred if the ship hadn't been captured.
They would not have been incurred.
They don't have to be contemplated at the outset.
My lord,
Your submission is presumed.
there's a little bit of law on what extra means in this rule, and what is suggested is that in advance of the voyage, one can pre-contemplate the ordinary sort of expense, the ordinary measure of expense that will be incurred in performing the voyage, and built into that is a measure of contingency for bad weather or delay or what might be called the ordinary contingencies of the voyage. But when one goes beyond the ordinary contingencies of the voyage, extra expense for the purposes of the rule may be incurred. It's not any expense that qualifies under Rule F. It's extra expense beyond that contemplated.
And it's got to be extraordinary, haven't they?
I'm sorry?
Have they got to be extraordinary? No.
No, my lord, that is not so. Extraordinary is only Rule A.
Yeah.
It's just got to be extra.
Well, if your ship had been,
Yeah.
if the pirates had damaged your ship,
Yes.
you would have borne the loss.
Yes.
And equally, if the cargo suffers from the delay during this period when you chose to negotiate,
Yes.
they would have borne the loss of value, wouldn't they? If the market had fallen or if the goods had deteriorated.
From delay, yes, my lord, if there's been a fall in...
Why shouldn't the owners bear the costs of delay while they're negotiating them? Why is it you alone can put into general average these costs?
Your lordship is moving me about in all sorts of directions, if I may say so. You're now asking me to address questions of delay.
Part of the fun of appearing in the...
Yes.
I'm just focusing effectively on why delay should be recoverable in this case
My
by
lord,
you and not by anyone else.
We say because Rule F permits it,
Well, that's circular.
But let me be clear. I'll come back to this point because this has been a deliberate incurring of additional extra expense for the common benefit.
Yes, but you can put, therefore, the cargo at risk. Supposing...
At risk.
Well, supposing during the period of 60 days or whatever the negotiations took, the value of the cargo fell, either because it was deteriorated or because the market value fell. They have to lump it.
My lord, we're now moving fast in various directions.
Good.
The payment of a ransom, it's true that ordinarily the ship owner conducts that negotiation essentially for practical reasons. He has the means of communication. He has the radio link or whatever to the bridge where the pirates are and the master of the vessel is. But there's no intrinsic reason why cargo interests concerned about the state of their cargo should not step in.
There's normally in most circumstances, one would say that delay leading to a deterioration of the cargo was not a sacrifice.
Yeah.
But if you, let's put it in terms of cogitation, whether or not that's the right test legally. If the owner says, I will get 4.15 million, or as much as I can, off this ransom demand, and in order to achieve that, I am willing to take the risk that the cargo will deteriorate, as well as the risk that the wage bill will be unnecessarily increased.
Yes.
Now, one possible answer to the dilemma raised by my lord is that both would be recoverable. That in those circumstances, deterioration of the cargo might be charged in general average. Now, what do you say about that?
Yes, there are a number of answers, but the first and easiest, if you like, is that...
When you say there are a number of answers, is your answer to my question that it would never be chargeable in general average, and you're about to explain why not, or is the answer to my question that it might sometimes be?
Rule F deals only with expenses and not with losses. Now, there have been a number of attempts in the history of the rules to get in substituted losses incurred in substitution for a saving in other allowable expense. But it's never been allowed, and the reason for that is that there is a concern that this might be a way, if you like, of protecting cargo interests from improvident transactions where they have bought at the top of the market and loss has been incurred as a result of delay, but they were in danger of losing that. The rule is explicitly clear that it deals only with expenditure.
Right. So although
so
sacrifice of the cargo might be chargeable under A, it's irrelevant under F.
It's irrelevant under F. That's my submission. It deals only with expenditure. My Lord,
There is law on that, you say?
My Lord, there's almost no law on Rule F at all.
I see.
We're going to show you the one case where it was considered very briefly. Obviously, if a cargo interest is concerned about the state of his cargo, he can take part in the negotiation as well. It's not exclusively a matter for the ship owner. No doubt the cargo interests, usually the insurers, the cargo insurers can get together with the hull insurers or the war risks insurers and say, well, hang on, we know you're concerned about paying general average under your cover, but we are concerned about deterioration of the cargo. Let us see if we can get the ship released faster, and that usually means paying more.
So your submission essentially is that you have to contrast the expression any additional expense in Rule F
Yes.
with the expression extraordinary sacrifice or expenditure in Rule A,
Yes.
in that, leaving aside the fact that extraordinary isn't required, sacrifice is irrelevant to Rule F.
And the difficulty with A, to be clear about it, is that it requires intentional sacrifice.
Yes.
And that may be difficult in the case of a deteriorating cargo. I don't want to disguise the difficulties, but Rule F has...
Well, it could be an intentional sacrifice if the risk was deliberately run, that the cargo would deteriorate while time was spent reducing the ransom.
I'm going to hesitate to answer that in the affirmative. I think that is unlikely. I'm trying to remember what my other point was. Oh, my Lord, one other point is this, that actually if expense is incurred by cargo interests, let's call it extra expense, your Lordships may have seen that the cargo in this case had an inhibitor in it to prevent polymerization.
Yes.
Because of the length of time that the vessel was held by the pirates, there was a concern that the inhibitor was running out of effect. And new inhibitor, extra inhibitor, was bought. Now, for our part, we can't see why the expense of buying extra inhibitor, and as was planned, injecting it into the cargo after the release from the pirates, should not also be regarded as an expense incurred in place of paying the first ransom, which would have made all extra inhibitor unnecessary. So it works both ways. This is not just ship expense. It can be cargo expense. The only question your Lordships have to address under Rule F is this expenditure incurred in place of another allowable expense?
And the fact that it's a type of expense that might not have been allowed under A is irrelevant, because we are concerned here with expense not, as it were, incurred under A, but expense incurred in order to avoid another expense which would fall within A.
Expense allowable possibly under A.
Yep.
Yes, and indeed I can take that point a little higher, my lords. The only time you need Rule F is when the expenditure you have incurred is not allowable under another rule. So you will have seen that the rule refers to these substituted expenses being deemed as general average expenses. That is in itself a recognition that these expenses are expenses that do not qualify otherwise as general average expenses.
But it's conceptually somewhat similar to suing labour costs.
It is, indeed it is. And to some extent, we've made this point in our case somewhere, to mitigation expenses.
I mean, I notice, I don't know if you're not saying there's a difference between expenditure in A and expense in F. as a matter of language, because the French use the same word, dépenses.
No, I'm not. No, A and F,
No, I
no,
just want to make sure.
expenditure. There's quite a lot of complicated drafting there.
Well, yes, but the French use the same word
Yes,
for both, so
yes.
I wanted to make sure, yeah. Thank you.
Now, my lord, I was taking your lordships through the judgment. I should warn you, my lords, I am quite badly adrift on time. Let me see what we can do over lunch, but I have quite a lot left to say.
We won't be here over lunch, but...
Let me see what I can do over lunch, my lords. I was just going to show your lordships paragraphs 52 and 53 of the judgment of Lord Justice Hamlin. And if your lordships just would care to read those at page 213, we have described these paragraphs in the judgment, in our case, as remarkable.
As what?
Remarkable.
Remarkable.
And if your lordship reads them, your lordship will see why. He says, the majority are making the point, this is a reference to the advisory committee, making the point, only one road is open to the owners in the course of a negotiation. That road leads to wherever the negotiation ends, and he goes on and says it is a single track road with no forks in the road, and it ends in the eventual ransom payment agreement, the end of paragraph 52. And he continues in 53, that there are no forks in the road is significant. Just as acceptance of the initial ransom demand is not a true alternative, nor is acceptance of any other ransom sum less than that initially demanded but greater than that eventually agreed. That means that the difficulty which troubled the judge and Mr. Madge about determining hypothetically what might be a reasonable ransom does not arise. Now, my lords, we don't frankly imagine that Lord Justice Hamlin was actually suggesting that as a matter of reality, in the course of a negotiation with pirates, there are in fact no choices to be made, no forks in the road, no questions about whether to submit now or continue negotiating further. But my lords, these paragraphs can be justified just about, or at least explained, on the basis that whatever the real world position was, the relevant choices were, in the reasoning of the court, simply the wrong type of choices. They were choices between what the, not choices between what the Lord Justice describes as true alternatives.
In other words, they're part of the same
They're
point.
part of the same reason.
Understand, thank you.
Yes.
Incidentally, having consulted my colleagues informally, it seems to me that the timing of this case appears to assume we'll finish a short adjournment tomorrow.
That was the...
If necessary, I don't encourage the parties to do this, but if necessary, we have got tomorrow afternoon.
My lord, I'm going to accelerate as best I can.
I'm sure.
There are issues still to cover.
I understand
haven't even got to issue
No,
2.
I understand that. That's why I'm saying what I'm saying.
Yes. Right. I'm grateful, indeed. My lords, that's the judgment. Perhaps I should also notice Sir Timothy Lloyd's judgment at paragraph 99. And
Yes.
really, that's just to show your lordship. It's the passage at the bottom of paragraph 99, 221 of the
Yes.
electronic bundle. He also puts it purely in terms of true alternative.
Yes.
The reference to real choice, if that is a separate test, if you like, for the operation of Rule F, doesn't appear there.
Thank you.
My lords, apart from the stray reference in paragraph 51 to Rule F presupposing the making of some real choice, the consistent thread is in the reasoning is the absence of true alternatives and the absence of an appreciation of a real choice is said, save for that paragraph 51, to support and reflect the supposed reality of no true alternatives.
Thank you.
2 immediate points in relation to that. Firstly, we don't understand how the latter can support the former or reflect the former. A subjective want of appreciation that there is a choice to be made cannot affect the analysis of whether the actual choices were or were not true alternatives according to the criteria adopted by the court. On the court's analysis, that depends on wholly objective matters, whether there were or were not different types of course of action available, or possibly whether there were different types of expenditure to be incurred. That's a wholly objective analysis.
On the Court of Appeal's approach,
Yes.
it would appear that if there were theoretically two courses, but it was absolutely plain and obvious which course any sensible person would adopt, one assumes that there was only one course, namely the latter.
That if real choice is the issue, then...
Well, it goes back to the requirement of agonising.
Yeah, it has that point. Yes, it's a point I'm coming to, and I can show you a concrete example where what I've called a no-brainer, where the choice is obvious.
Yeah.
Now, my lords, so my first point here was that I don't understand the intersection between real choice and true alternative. Real choice appears to depend on subjective cogitation or appreciation on the part of the owner of there being a choice. True alternatives is a wholly independent, objective analysis. That's my first point. We make this point in our case, paragraph 68. The second point is perhaps a little more subtle or difficult. And turning now to true alternatives reasoning, if in the eye of Rule F there is from the moment of the capture of the vessel no legally relevant alternatives to paying the ransom finally paid, in what sense can the eventual payment of that ransom be regarded as an intentional act for the purposes of Rule A, under which it would otherwise be allowed? One has to suppose that the straitjacket of Rule F, if we adopt the Court of Appeal's reasoning, which requires one to ignore all options that are not true alternatives in their language, suddenly vanishes at the moment of deciding to pay the final ransom. And at that point, suddenly one says that the payment of the final ransom is an intentional act under Rule A, the product of an actual intentional choice. Now,
Does it have to be a choice under...
It has to be an intentional act under Rule A.
Yes, well, the intention is to pay the best ransom negotiated.
Yes.
I'd say it's formed at the beginning. That's a choice to do something rather than leave the vessel.
Well, when you pay the final ransom, you are exercising the choice to pay now rather than argue or negotiate further. That is the decision made then. That suddenly is an intentional decision, but all other choices prior to that moment are in the eye of Rule F, according to the Court of Appeal, to be ignored as not true alternatives. That's a very puzzling state of affairs and shows a considerable tension between the reasoning, Court of Appeal's reasoning on Rule F and the operation of Rule A. Now, my lords, we think that true alternative is the reasoning of the Court of Appeal, and that is what I intend to address first. This is reversing the order in which matters are dealt with in the case. I will have to come back to real choice, even though, well, in our submission it isn't the basis upon which the court proceeded, but my friend makes something of it. I'm coming up to 1 o'clock. This may be a good point to break, and I will come back and address true alternative as a line of reasoning.
Very well, thank you very much. We'll resume again at 2 o'clock. Court's now adjourned.